Begin with our top story. Of course, the Constitutional Court has finally made its ruling on the CR17 campaign. It found the President, Cyril Ramaphosa, did not deliberately mislead Parliament about the donation made to his CR17 campaign. It also found the Public Protector had no scope to investigate the funding of the campaign. For more on this, eNCA senior reporter Avuwe Mtila joins me now from the Constitutional Court. Avuwe, another blow to the Public Protector and her office.
Certainly, Maseko, yet another blow as we found out here that the President did not willfully mislead Parliament. And in fact, the Public Protector had no scope to investigate the CR17 campaign and the funding around it. She went over and above what she was mandated to do, we heard here, as Justice Jafta gave that ruling. I just want to read some of the asterisks there. As you remember, this issue was brought up by Mmusi Maimane, the then leader of the official opposition, the Democratic Alliance. In fact, in an affidavit that we understand came from one of the employees of the Africa Global Operation, which was previously Bosasa, admitting to that 500,000 rand donation given to, we understand, the CR17 campaign. But even in that affidavit, we understand, Justice Jaffa mentions that Mmusi Maimane was not aware that this question was factually incorrect, the question posed to the President in Parliament. Maimane at that time thought that the money went into the President's son, Andile Ramaphosa, where in fact that money went into the EFG2 trust account for the CR17 campaign funding. So the President did not willfully mislead Parliament in that context. I just wanted to listen to some of the extracts from Justice Jafta as he delivered that judgment.
It appears from the report that the Public Protector accepted that the President was not willful. In one part of the report, the Public Protector recorded that the President's open code conduct referred to above, although in good faith, is inconsistent with his office as a member of Cabinet, close quote. But instead of making the finding that the President did not willfully mislead Parliament, the Public Protector effectively changed the wording of paragraph 2.3a to include deliberate or inadvertent misleading of the legislature so as to cover the situation where willfulness was not established. On the basis of the changed code, the Public Protector concluded that the President, open quote, inadvertently and or deliberately misled Parliament in that he should have allowed himself sufficient time to consider the question and make a well-informed response, close quote. The Public Protector was wrong to change the code. She could not have conceivably thought that willfully could mean inadvertently. These words are mutually exclusive. What she did went beyond the parameters of interpretation, but the finding itself is framed in terms that are concerning. The President could not inadvertently and deliberately mislead Parliament because these two words cannot apply at the same time. It is either one or the other. Therefore, the Public Protector was wrong on the facts and on the law with regard to the issue whether the President had willfully misled Parliament, and the High Court was right to set aside her finding.
All right, Avuwe. So although Justice Jafta, as he was handing down the ruling, said that the Public Protector actually was overreaching in investigating the private matters of a political party, Chief Justice Mogoeng did dissent and said that the President actually does have an obligation to announce or to disclose who his donors are.
That's the one issue, in fact, that still was set aside, the issue of the ethics code issue. In fact, it came up in that judgment that we heard in March at the Gauteng High Court, where it was set aside, we understand, an issue raised by Amapungane, which we do now understand it's been set aside with cost to the president, and in fact is supposed to go back to the High Court, we understand, which will now look at whether the ethics code is it unconstitutional to failing the required disclosure of the political party funding, because we do understand that's the bone of contention, whether the president, for example, and the MEC's deputy president and premiers are supposed to disclose funding that they received. It was previously found, we understand, in the High Court that they're not supposed to disclose that. But now the Constitutional Court suggests that that needs to be looked at, whether it's unconstitutional for them to require to disclose that. So that's the issue that will be looked into. But when it comes to the merits of this, remember that the public protector found that the president personally benefited, in fact, in that 500,000 rand money. But we heard in this court that the president wasn't even aware of this. Remember when this matter came up in Parliament, the president suggested that it was a business transaction to his son from African Global Operations, but later retracted that statement once he was told that it was for the CR17 campaign funding, which he says he wasn't a part of and is not involved in anyhow. So this court found that the president couldn't have personally benefited in that. In fact, even the suspicions of money laundering, that matter was also put away, rested to bed, that we remember that the public protector suggested that 500,000, that R500,000 rand that went into CR17 campaign moved from one account to another, but it was cleared out here that it went directly from the African Global Operations to the G2 trust account, which you do understand is for the CR17 campaign. So suspicions of money laundering have been put aside here. And in fact, we do understand that the president did not mislead Parliament. And in fact, the public protector herself went above the complaint that she received in the scope in investigating the CR17 campaign.
And Aviwe, this also shows how important the debate around political party funding is.
Certainly is that debate. In fact, you'd understand that there's also this Political Party Funding Act coming into play in April. So even the matter around the ethic code of conduct may be put away, may not even go back to the High Court, seeing that there's that Political Party Funding Act that's in place now, opening up to those disclosures. In fact, it's a conversation that Paul Hoffman touched on yesterday around the transparency. And in fact, the people that put in money into the political parties, as well as individuals for their personal campaigns, because we do understand the public protector in that discredited report from July 2019 touted millions that were poured into the president's campaign. So questioning whether those people that are putting in that money, what would they benefit, suggesting that there could be implications of state capture. Even Paul Hoffman, the constitutional expert, saying that we should be cautioned in terms of who puts in money to the various political parties to avoid a situation which we have essentially that would look into the state capture, even mentioning the Gupta involvement in the allegations of corruption that we've seen in the last number of years.
All right, eNCA senior reporter Aviwe Mtila out for us at the Constitutional Court in Braamfontein. Thank you.